Well, we heard from the Justice Minister on the extradition process and his role at the very end of that process. But what should we watch for in the days and weeks ahead? What is involved in the court's decision whether or not to extradite someone from Canada? How will the courts decide on a case like that of Meng Wanzhou, and how long will it all take? Joining me now from Toronto is Seth Weinstein, a specialist in international and extradition law. Mr. Weinstein, first of all, thanks for joining us. Good to have you take some time to help us understand this process. It's good of you.
My pleasure.
The Americans have now formally made the request for extradition of Meng Wanzhou to the U.S. from Canada to face charges of fraud and skirting those U.S. sanctions against Iran. What happens next in the extradition process?
So the next step is, now that the request has been filed, the Minister of Justice has 30 days in which to issue what's called an authority to proceed or not. And the authority to proceed is essentially the charging document that would be put before the court to commence the committal hearing to determine whether she ought to be committed for extradition. So they have to approve the request now, and if it's approved, then they will issue the authority to proceed within 30 days.
And what happens in, you called it that committal process, what happens in that process? Is that effectively the laying out of information to decide whether she goes or stays?
Essentially. So what it is the requesting state is obliged to present some evidence of all essential elements of the offense and satisfy a judge in the Superior Court that there is sufficient evidence to commit her for extradition. What they have to lead is some evidence of conduct that, if it occurred in Canada, would amount to a criminal offense in Canada. And so that's where they present the evidence. It's mostly done in affidavit form, where they file what's called a record of the case with the court, and the judge assesses the information and the evidence within that record of the case to determine sufficiency and determine whether there is sufficient evidence to commit her for extradition.
All right, interesting. So we should expect this to be largely a paper process. We don't expect to see a delegation of American officials in a Canadian courtroom making the case, do we?
No, generally speaking, it's done on paper. There are sometimes and occasions where there is some viva voce evidence called, but essentially the Extradition Act permits the requesting state to file their materials in written form. There are certain requirements that have to be met in terms of what is required in writing, but it is essentially a written process at that point. There could be evidence called on other issues, but generally speaking, the sufficiency of the evidence is determined through the record of the case.
All right, this arrest has caused Canada lots of problems with China. Canadians have been detained in retaliation, it would seem. The Chinese keep insisting Ms. Meng should be released. How long could this process take? How long could it go on?
It can go on for quite some time. I mean, what'll happen is the first step is the committal phase. That's the judicial phase. That can take months, even longer. It could take a year, some not usually longer than that, but it could take some time. After that, there's the second phase, which are the submissions that are made to the Minister of Justice, asking that he not surrender her and raising arguments as to why she ought not to be surrendered. And from both of those proceedings, there are rights of appeal of the committal decision, and there are rights to judicial review of the minister's decision. So when you exhaust all your appeals and applications for judicial review, we're talking years, not months, in terms of the whole process before an actual surrender order is issued.
Right. Let's drill down a little bit, if I can, on some of the things we've been hearing. Our now former ambassador, John McCallum, was fired after he suggested Ms. Meng had a strong case against her extradition. He referred to two arguments she could make. Let's look at the first one. He referred to political interference that the president of the U.S., Donald Trump, had already commented, saying he could be ready to intervene in her case. How significant an argument is that?
Well, I obviously can't comment on the merits or the strength of any arguments. I'm not privy to any of the information. What I can indicate is that there are arguments that could be advanced that if there's evidence in support of the argument that this is merely a political prosecution, or that our extradition proceedings are being used for political purposes and not for legitimate law enforcement purposes, that could be an argument to deny her extradition. It could be an argument to essentially argue that it is an abuse of process. So that argument would be, if the evidence exists to that effect, certainly that is an argument that can be advanced.
And how reluctant are Canadian courts to grant extradition if it appears there's a possibility that a foreign government is actually using the process for political purposes?
Well, again, if it can be established that it's an abuse of process, then the only remedy at that point is to stay the proceedings if there is an abuse of process. But I mean, generally speaking, extradition proceedings, as a matter of course, are ones where extradition is often ordered. But if there is evidence in support of an abuse of process, then the courts are going to enforce Canadian law. And if it is an abuse of process in the eyes of the Canadian law, then extradition will be denied.
The other reference Mr. McCallum made was that the offense she's accused of has to be an offense under Canadian law. She's being accused of false statements and fraud in an effort to skirt U.S. sanctions against Iran. Is it clear that she's broken Canadian law?
Again, I can't comment on whether it's clear or not whether she's broken Canadian law. Again, if what Canada does in the extradition proceedings is they take what's called a conduct-based approach. What they do is they don't look to the offense, the name of the offense. In this case, they've named it fraud. They don't look to simply the name of the offense and say, is fraud an offense in Canada? And if so, we extradite. We actually look to the conduct. And so you have to look to the underlying conduct that's being alleged in support of the extradition. And if that conduct is not conduct that amounts to a criminal offense in Canada, then it will not meet it's called the doctrine of dual criminality. It would not meet that, and if it doesn't meet the dual criminality test, then again there'd be no basis to extradite. But you have to look at the underlying conduct that is being alleged, and that's what will be alleged in the record of the case.
Do you have any sense of how often Canada refuses an extradition request in the end? Is it really extraordinary to say no?
I'm not going to call it extraordinary, but I think certainly it is not common for extradition requests to be denied, but it happens, and it happens when the requesting state has not complied with their treaty obligations, or if they abuse the process in any way. Certainly extradition will be refused in those circumstances. I mean, extradition, generally speaking, amounts to the surrender is often made, but not always. And there are cases where it's been denied for abuse of process, or that there's a lack of evidence, there's a limited evidence or no evidence in support of the request.
All right. Will you be paying close attention to this case as it moves forward? And if so, what are you looking at?
Well, I mean, again, we're looking at, I mean, this is, I find every extradition case interesting, so I'll be looking at how the law is applied in the context of issues such as dual criminality, if there are arguments in support of the abuse of process issue. So I mean, I'm going to be looking at those issues and obviously following it as closely as I can, but not being privy to all the information. It's difficult to know for certain what will obviously happen.
Right. I think for most Canadians, this is sort of a new introduction to Canada's extradition laws, but it's in the context of this very important international story that involves Canada, the Chinese, and the United States. So it'll be in the news for a while. Seth Weinstein, thanks for your time tonight. Appreciate it.
My pleasure.